Before we begin this daf, this shi'ur, beginning of a new chapter, I would like to make some disclaimer. The subject I'm going to discuss is, if not the most, it's one of the most sensitive and touchy subject that carries a tremendous amount of emotional weight for many people. Gdolei Israel, the luminary rabbis, struggle with this issue, which is the issue of agunot, deserted wives. I know of many stories of great rabbis that didn't sleep, didn't eat, didn't drink for days while they are in a search to find a solution to a situation like that. We're going to deal with a state of uncertainty. One example is the late Rabbi Ovadia Yosef, which, as you know, I have the privilege to know him very well. He really dedicated a big part of his life to find a way for solution for those crises, particularly women in crisis. So since it's called Sugiyot Chamurot Bashas, this is one of the very serious subject, I want to say it very clearly that no one should take this session in a sense of practical halachot. When it's come to those questions, one should ask a prominent posek, a prominent rabbi, before going ahead and making decisions. A small example is the very rare leniency that comes here, which is accepting one witness, for example, or accepting some people who are usually not accepted in a rabbinic court. So again, with that said, and with my recovering voice, we'll start with this Perek Ha'isha Rabbah, Perek Asiri, the 10th chapter of Tractate Yevamot, B'tchilu Urchimu. Page 87b, Ha'isha she'alach ba'ala limdinat hayam. Woman, married woman, the husband left. In our days, 2015, we can speak about he went to a mission to Afghanistan, to Iraq, to China for certain job involvement, and people came to her and said that your husband is no longer among the living. ובאו ואמרו לה מת בעלך. So even the Mishnah used the plural term, באו ואמרו. Rashi explained to us that this applies to one person. So try to be practical, and let's go to just the extreme. I think Gilbert, you told me a similar story. It was some conflict between a husband and wife. I don't know if you remember. And he just left. He said he's going to Panama or Mexico or something like that. And you never hear from him for a long time. Then another fellow came back and he said, I saw him dead, or I read in the news, or I heard that he's dead. As a result of that, Mishnah said, Veniset. So because usually when it's come to Dinei Ishut, the issue between husband and wife, we require two kosher witnesses, two very reliable individual, Shabbat observant, people whom we trust, not a gambler, people who have a good reputation, clear criminal record, etc. And those two people comes and give us a witness when we want to marry or when we need to go the other way to divorce. The rabbis, however, as we said earlier, when it's come to women in crisis, they went the super extra mile, and they are more lenient to accept one ed, one single witness. Otherwise, Rashi tells us, and you hear it later in the Gemarrah, page 88, that she will never be able to be free if you don't accept one single person. I remember in my childhood, it was a submarine, Israeli submarine, Dakar, that was missing. And it was, I do not remember the exact number, but large amount of women that potentially can have children. And they are stuck in limbo without knowing if the submarine is coming back. And as you know, always people come back and said, I saw something, it's a sign, they're coming back, they may be in captivity, maybe. So, thank God, in the modern days, the chaplain in most of the places, I know in US forces, I know in Israeli now forces, they ask whenever a soldier go to a special mission to leave a get, to leave something to his wife, so she will be able to marry, to have children, etc. So here, we allow her to get married just by one witness, even, as we said, it's the exception, but here is the crisis. ואחר כך בא בעלה. And all of a sudden, the husband came back. So, here is the problem. It's a double problem. Because her act of marriage is ineffective to both of them. Meaning, originally, she was a married woman. Because that witness, and because she didn't hear for a long time from her husband, we allow her to marry someone. But now, since the husband returned, she is basically prohibited to both. Why? Because in one hand, she is married to the first husband. On the other hand, she is in violation of having relation as a married woman. And now you see all the dinim. So first we should know, when the Mishnah said v'amrula meaning the bet din. The bet din said to her, meaning one witness come before the bet din, and he witnessed and he said, I saw him dead. Soon you see what does that mean. He saw his head, he saw his leg, he saw his part of his body, he read in some place. It's he, it's she, what exactly involved? Is Jewish or not makes a difference. But for our understanding so far, we're talking about one person. One person came and said, and the Bet Din approved it. So, basically, as we said, this is one of the rare kulot, one of the rare leniencies, that the Bet Din said, okay, we allow her to get married. But the problem is, what do you do now? So basically the Mishnah speaks about 16, listen to this, 16 consequences of that action. 16. Some of them apply to a regular married couple that involved with mistake. Some, it's a special fine that she received from, in a way, impetuous behavior, which again the Meiri explained. So let's go first to the Mishnah. Tetzeh mizeh umizeh. In general, the Gemarrah tells us in Tractate Sota, page 27, that a married woman who involved with an intentional adultery, meaning it was not an act of rape by any means, but she totally consent to have relation with another man, she is automatically prohibited to both, to a husband and to that person. meaning even she get divorced or she became widow to neither one of them, these two is over. She cannot have anything to do with them, period. However, if it was an act of rape, meaning she wasn't consent to that, she allowed to her husband or even to that person after she get divorced or she's become widow. Now in our situation, you cannot blame her by any means in any form of adultery with the second one. Why? Because the Bet Din allows her to marry to someone else because they depend on one witness, one single person. So therefore it's a concept that's called Isha Daika Uminasva. Usually women checking very carefully before they married someone, especially in this situation. Remember, she is a married woman, and the husband is no sign for him for a long time, and now is a witness come in and said that I saw him dead, so, and the Bet Din approve it. So she is now in a situation when she went ahead and married, she basically checked it carefully. So therefore, number one, we said in a list of 16 consequences, number one, tetzeh mizeh mizeh, meaning she needs to get out of the marriage of the original husband and from the second one. Utzricha get mizeh mizeh, meaning if she make a decision, she wants to marry someone else, which again, we talk now about C. Let's use a number, ABC. So let's call the husband A, Abraham. And then the second one that came to a picture is, let's call him B, let's call him Benjamin. And now she wants to marry C. So in order for her to marry C, she needs to have a get from both, from her original husband that was missing, and he just returned, and from the man she married because of one witness. Furthermore, and now you should know, just as a side note, we have a difference between get a bill of divorce by the biblical term, the bill of divorce by rabbinic term, meaning the first husband, meaning the original husband, he needs to provide her a bill of divorce by the biblical terms. The second one is the rabbinic rules. Why? Because the rabbis came in and said, let's face it, she cannot get married because the husband was alive. The fact that she was mistakenly married may lead other people to misconstrue the concept of her being married or even unfaithful in a way. So therefore we require a double get, one by rabbinic law that applies to the second one, and the second get from the biblical law that applies to the first husband in order for her to marry the third one. Then we said, ve'ein la ktuba, as we all know, when it's come to marriage, the key point is the ketubah. Ketubah is the marriage agreement between husband and wife, that it's written there, all the details, the contract, what exactly he is obligated toward her. And it's involved with all the specification, etc. Here, she lose her ketubah, it's a knas. It's basically, in a way, she lost the capability to receive money from the original ketubah. Velo perot. She, basically, we have a concept, if you remember, we learned the nichsei tzon barzel, nichsei milog, if you remember, we learned in the previous parak, that sometimes involve in the marriage some properties bringing fruits. So the second husband ate fruits that he is not deserved to receive those fruits of that property because she married him by mistake. So therefore, is nothing to do with returning that part. Later we explain it on page 89. Velo mezonot, which means, obviously, since the original husband, Abraham, need to divorce her, he is free from supporting her, from paying her alimony. So now you ask a question, why we repeat ourselves? So Rashi explained to us that this was not the greatest husband in the world, meaning he left her without money. Gilbert, you know anybody like that? And he disappeared. She didn't hear from him because, who knows, it was some conflict. And she saw she cannot carry on, so she went to his cousin or his friend and she borrowed money. And now somebody came in and said that he's dead, and she married someone else, and now her husband came back. So the question is, does the husband obligated to pay back the loan that she took at the time he left? In general, we said that the husband needs to take care of those loans because she is part of his ketubah, part of his commitment. But here, he is free from that. Later we explain why. Velo blaot, that's nichsei milog, that's the clothing. Lo al ze, velo al ze. She is not receiving any payment, neither from the first one, nor from the second one. The idea is, obviously, on page 89, we explain that the second husband, since it's not in a way legitimate, it turned to be a ineffective or fake. But the chidush here is the first husband, basically by having her married someone else, even by mistake, the first husband is free from paying any debt that collected in the past. ואם נטלה מזה ומזה תחזיר. If she took any possession, any money from neither one of the two husbands, she is obligated to return them. והוולד ממזר מזה ומזה. Now we go much serious, and we say that the baby that was born, if, for example, the husband left on January 1st, and they receive a notice a couple of weeks later from someone that he passed, and then she married several months later, usually we're waiting 3 months to make sure that she's not pregnant, okay? But in general, if she became pregnant from the second husband before the first one returned and divorced her, then biblically speaking, the baby is illegitimate, is mamzer, because it's the baby that was born from a married woman. And the baby was born, if in our modern days you have DNA, and it turns to be a baby from the first husband, it's mamzer by the rabbinic law. Next, lo ze veze metamela. If the husband, either one or both, are kohanim, usually we know that the kohen are prohibited to contact the corpse, a dead body. The exception, the Torah said in Leviticus chapter 21, there are 7 exceptions, which is husband, wife, son, daughter, brother, sister, father, mother. So that's the 7. So since the husband or the husbands is or are kohen or kohanim, because it was in manner of adultery, even unintentional, then automatically they are out of a business of contacting the dead body by any means. Meaning, usually there is a mitzvah for the person to come and contact the dead body and help. But here it goes the other way. Why? The second husband is not his real wife, and the first one is something that we explain a little later. Next one, we have a list. You remember 16 items. 16 items involved here. So the next one, ולא זה וזה זכאים, לא במציאתה ולא במעשה ידיה. The sages put a decree that when it's a relationship between a husband and wife, he is obligated to support her, to shelter her, to take care of her sustenance, etc., etc. By the same token, if she found something, it belongs to him in a sense. It belongs to him since she is under the roof of him. He is the one who, in a modern days, you call it breadwinner, right? And also, the Mishnah in Tractate Yevamot, page 65, said that the income, the second husband never entitled to that, because as the Magid Mishnah in Ilchot Gerushim tells us, she was never his wife. The first one lost his right over that because, we explain soon why. Velo ba'afarat nedareha. The Torah tells us in the book of Numbers, chapter 30, that the husband can annul, can expunge, abrogate the wife's vow. Meaning, if she make a vow without his consent, she make a vow that causes sorrow, etc. For example, she make a vow not to eat, not to take a shower, whatever it is, right? Or anything related to relation between him and her. So the husband can, by mean of his power, he can abrogate that. Versus the second husband, that was not really true wife to him, so therefore he cannot do it. Why the first one lost it? Well, again, we explain it later in the Gemara. Hayta bat Yisrael nifsela min hakeuna. If she was a regular Jewish woman, daughter of Israel, nothing to do with Levi or Kohen, she is basically from now on unfitting to marry a Kohen. Why? Because the relation with the second husband came out of violation of Torah laws. So therefore, the Torah said in Leviticus chapter 21 verse 7 that automatically this type of zonah, she is prohibited to Kohen, so she cannot no longer marry a Kohen. Ubat Levi, if she was a daughter of Levi, he entitled to receive the first tithe, mina maaser. She lost that opportunity. That's part of the knas. Ubat Kohen, if she was a daughter of Kohen, mina truma. The Torah said that the special contribution allows to be used only by the Kohanim and their household. Daughter of Kohen that married out, meaning married someone who's not, she is no longer entitled to receive the truma. If she lost her husband or she divorced him without having children from her husband, she can go back to her father's house and can eat from the truma. But here the sages come in and said, even she have no children from the husband, because it was an act of adultery, she lost the capability of eating from the truma. ואין יורשין של זה, ויורשין של זה יורשין את כתובתה. Here we're not talking about the ketubah itself, but we talk about the heir, meaning the inheritors. So we said that the inheritors cannot, neither the heirs of the man nor the heirs of that one inherit her marriage contract, as she is not considered married to either of them. So, ואין יורשים של זה, יורשים של זה, יורשים לכתובתה, ואם מתו אחיו של זה ואחיו של זה, חולצין ולא בימים. So, if they both died childless, the brothers of this one and the brothers of this one must perform וחליצה, which is acts of release, and they do not enter into levirate marriage, because, as we said, that's part of the brother of the original husband was the real one that entitled to be avam. But the sages came in and said they cannot do a levirate marriage, and the only way is to release her. That's the וחליצה, that's part of the knas. So let's wrap up the 16 point we learned if someone married by the witness of one person. So the 16 point. 1, she need to be released from both, from the first and the second husband. 2, she need get from the first and the second husband. 3, she cannot receive the ketubah from neither one of them. 4, she cannot have the right over returning the fruits that the two husbands ate. She cannot have a return of any alimony expenses from both. She lost the right over clothing from both husbands. The children, number 7, the children of neither one or both are mamzerim, illegitimate. If one or both of the husbands are kohen, he cannot render ritual impurity by her passing. 9, if she found something, neither one of them has the right. Imagine if she won a lottery, she have $10 million, neither one of their husbands have any right, any access to that money. So it goes in a way both ways, right? Number 10, anything that fruit of her labor, neither one of the husbands have the right over that. Number 12, she's disqualified from marrying a Kohen from now on. 13, if she's daughter of Levi, she can no longer eat from the tithe. If she's daughter of Kohen, she can no longer eat a truma. The inheritors of neither one of them can inherit anything from her ketubah. And the last one, number 16, neither one of the brothers of the husbands, if the husbands are deceased at this point by any means, neither one of the brothers can do act of levirate marriage. The only thing they do is וחליצה. Now here we enter to a domain of disputation by some of the rabbis over some of those rulings. Let's go to some of them. First we go to Rabbi Yossi. Rabbi Yossi אומר כתובתה על נכסי בעלה הראשון. So Rabbi Yossi disputed the third point, and they said that the sages did not exempt the first husband from the obligation of paying the alimony, paying the ketubah, after they divorce or after his passing. The Gemarrah later on page 91 elaborates on that. The second one is Rabbi Lazar. Rabbi Lazar אומר הראשון זכאי במציאתה ומעשה ידיה ובהפרת נדריה. He goes for several things. He disputed number 9, number 10, and number 11. He said that the original, quote-unquote, true first original husband, he's right, and it's not in a way his fault, and therefore he is entitled, if she found something, if she have a labor, or annulling her vows, the original husband entitled to that, because it wasn't his liability or responsibility, fault. The third one, Rabbi Shimon Omer, he disputed basically the number 16, and he said, ביאתה או חליצתה מאחיו ראשון, של ראשון, פותרת צרתה, ואין הוולד ממנו ממזר. He said that the bi'ah, the relation with the yevama or וחליצה from the first one exempt the co-wife from ייבום, and the child is not any issue of legitimacy. So again, Rabbi Shimon disputed the Tanakama, the first one, that if the first husband have relation with her after he returned from being missing, he came back and he have some type of cohabitation with her, the child is illegitimate by rabbinic law, but he agreed that any child from the second husband is mamzer by the biblical law.
Why does this brother of the second husband have to perform וחליצה? Why is there a zikah bond with the brother of the second husband?
That's the dispute between Tanakama and the other one. Because...
Well, I mean, but Rabbi Shimon is saying specifically here, we're talking about the co-wife being exempt. But I'm talking about why is there even an obligation for וחליצה at all for the brothers of the second husband? Because that
people are stupid, excuse me my language, and people think that they are really married couple, and therefore people will maybe think that because they are married and people doesn't know the difference. So they said, oh, how come the brother of the second husband cannot do ייבום? Right? So we make it clear.
Well, no, I mean, I understand why you can't do ייבום. If there's no zika bond, then you shouldn't have to do either.
Correct.
I mean,
correct. But let's face it, most of the people are not familiar with all the nuances, and they don't understand the huge difference. Even both of them are prohibited to her, but it's huge difference between someone who marry her by the Torah law in a regular manner versus someone who marry her because of one witness, and the husband was missing for short time or for a certain period of time. Now we go to another subject. It's more enigmatic part of this sugya. People do not understand the difference between one witness to two witnesses. So the Mishnah said, "Ve'im niset shelo birshut," which means if she married without the consent of the rabbinic court, basing herself entirely on the testimony she heard, and a husband returned. So it means that the two witnesses came and they testified before the rabbinic court that the husband is dead. Then the husband returned. So again, what's the real difference? When you have two witnesses, the bet din, in a way it's a bet din, but the two witnesses is the essence of what's going on. Why? Because the bet din listen and approve, and they said okay, and they can get married. But if it's one witness, so when it's come to arayot, one witness is not allowed to go ahead and have another married. So you need a ishur bedin bedafka. You need a special session, a special approval of the bedin. So that's the idea shelo birshut. So muteret lachzor lo. What is muteret lachzor lo? It means that she can go back and permitted for her to return to her first husband. Now the Mishnah basically the Mishnah used the term anusa, that it was a force of circumstance, it wasn't her fault. Now it's davar veipucho, it's something and the opposite. Niset al pi bedin. So now the Mishnah adds another difference between these two scenarios. If she married by the permission of the rabbinic court, meaning someone in the Torah law, we different between someone who does something intentionally and someone does something unwittingly. So someone who does something unwittingly, he needs to bring a sin offering to atone for his sin. Part of that is someone who will have this type of cohabitation of married women, but in a sense it was unintentional. So they said niset al pi bedin. She get the permission if she married by the permission of the court, which means just by one witness. Tetzeh, she must leave both of them, both of the husband. Uftura min hakorban, and she is exempt for bringing the sin offering for her unwitting adultery. Why? Because she is the authorization of the rabbinic court, and she is therefore considered to have acted under duress, meaning she have no other choice. Lo niset al pi bedin. But, however, if she did not marry by permission of the rabbinic court, potra min teitzeh v'chayevet bekorban. She must leave her second husband, and she is liable to bring an offering by mistakenly having relations with a man forbidden to her. Now we continue. We said yafeh koach bedin. In this regard, the power of the rabbinic court is greater. Potra min hakorban, as she is exempt from bringing an offering. So Rashi said, אלא בעדין חייבת קורבן לשוגגת היא ואין זה אונס להיפטר מן הקורבן דיבה אלא להמתונה. So here is the issue. He says, הורו הבדין להינשא. So if the court instructed her to get married on the basis of inaccurate testimony, והלכה וקלקלה, and she went and ruined herself by engaging in a very illicit relations outside of matrimony. Meaning, later the Gemarrah in 92 explained it. And all of a sudden it turns that the husband was alive. So they said, chayevet bekorban, she is liable to bring an offering, shelo hitirua ela leinaseh, because they give her permission only to marry and not to engage in any other illicit relations. So there is a Tshuvot Rabbi Akiva Iger that said, it's a famous story about Rabbi Akiva. He was a great rabbi, posek, and they came to him to permit a aguna, a deserted wife, to go ahead and marry someone. So he said, all right, all the evidence, everything is okay, but he said to rabbinic court, give me a couple of days. And he turns, he said, I don't know why, I feel that I need some time. And he turned that the husband came back. Mm-hmm. So you see now, as we said earlier, how sensitive is this subject when it's come to this. Rashi said at the very end of this, writing the Baile Amtune, sometimes you need to wait. The question is how long you can ask a person to wait. As we said, in the case of the submarine Dakar, the Israeli submarine that was missing, if you remember, if I'm not mistaken, it was at the 70s. So with so many sailors, so many soldiers who married, and the wife, or deserted wife, they cannot get married because any moment you have a different news. Maybe they are in captivity, maybe they're in Russia, maybe they're in Egypt, maybe who knows where are they. So meanwhile, they're stuck. But you can argue and said further that even in the modern days, you have a situation that in some chaplaincy, some chaplain ask the people who go through a special mission to leave a get by the chaplain. Person go to Afghanistan, person go to all kind of dangerous area. So it can be the rabbi of the community, it can be the chaplain in the army, whatever it is. He asks the person to leave a get.
When did they find the submarine? Or did they?
Much later. It's like
10 years later?
20 years later.
20 years later.
One of the things that many Israelis regretted is that the rule of the chaplain asking every soldier to go to a special mission to leave a paper wasn't in effect at that time. So, and the big debates that the rabbis argue at that time is how do you release, and what happens if the husband come back? It's as we said earlier, it's a very, I can say that I gave example earlier, Rabbi Ovadia Yosef, but many other Gedolei Israel, the great rabbis that didn't sleep, didn't eat for a long time, just try to find a way to release those women. I knew some colleagues that they have a mission in life. They go to the Amazonas, they go to Thailand, to Nepal, to China, try to find husbands who just left year 2, 3, and who knows. And they go to agencies, to embassies, to Chabad houses, all kind of places in Kathmandu, in Nepal, and they somehow talk to a husband, convince him to write a get and release her. I know 2 rabbis, 2 colleagues that does that all day long. That's what they're doing. They go flying all over, try to catch husbands and just talk to him, convince him to write the get because you cannot force him. When I was a rabbi in New Jersey, I have one case that I was involved with this. Was a man that big conflict with his wife, and he refused to give her a get. And I went to his place. It was a big car dealership in New Jersey. I sat with in his office, and eventually I get him to sign the get. And I tried. The key is I told him that the get shouldn't be part of the divorce agreement and monetary agreement. She can go ahead and marry another man and not lose the opportunity to have children, etc. So anyway, Midiktane Sefer, now we're going to the Gemara. Now the Gemara starts with the first case in the Mishnah, when they come to her and say the husband is dead. So the Mishnah use a plural term. They use the word ba'u. Ba'u meaning more, not ba, ba'u, meaning more than one person came in. So it appears like two witnesses or two people came and told her that. Midiktane Seifa, because the last clause of the Mishnah said, Niset shelo birshut. They said that if she married without the consent of the rabbinic court, muteret la chazor lo, she is permitted to return to him. This indicates that she did so shelo birshut bedin, ela be'edim, that not with the consent with the rabbinic court, but rather with the witness, meaning that there are two witnesses and she does not require special permission from the court. Michlal, from that we derive the reisha, the first clause of the Mishnah, birshut bedin, that she have a consent of the rabbinic court, and referring to a situation ube'ed echad, where there was only one witness. As we said, some cases even part of the body was found and you have one witness, soon you see. Alma ed echad ne'eman. I repeat myself again and again, we should not have a practical manner of halachot for what we study now. We ask a prominent posek for this, but the idea here, what apparently is something that elaborate here, you don't see it in the Mishnah. They said here apparently one witness is deemed credible when he is testifies about the husband's death, which means the rabbinic court will permit a wife to marry on the basis of the testimony of a lone witness. And we see another source for that. So again, you don't see it clearly in the Mishnah. We now elaborate on that concept, which again is extreme leniency. Utnan Nami, we're going to study on page 122. Huchzeku lihiyot masi'in. They established that they would allow a woman to marry if a husband was reported dead by one witness, based solely on that he learned. For what? Liyot masi'in ed mipi ed, ve'isha mipi isha, ve'isha mipi eved, mipi shivcha. That's amazing, because here you see based solely on what he learned from the mouth of another witness, which in a way, in a regular court matter, it's the hearsay evidence. It's a hearsay testimony. Someone said something. But also testimony of a woman who heard from another woman, or even the testimony of a woman who heard from a slave or from a maidservant. Imagine the man went to some places in Africa, right? And you hear it from some people on some of the tribes in the jungle that said that they saw him, they saw him dead. And you hear it from someone who hear it and you come before the Beit Din. So it's like a double hearsay testimony. Apparently, Alma, Ed Echad Me'eman, this is again, we go to the extreme because we try to release her from this huge agony. And we said one witness is deemed credible in this regard, and whenever hearsay testimony is accepted, the testimony of one witness is also valid. Meaning, she can go ahead and marry someone else just by one person that gave a testimony in such a way. Now, we go further to the next step. So far we talk about aguna, meaning deserted wife. But here we're going to show that that's applied to other manners. And Tosfot said that we can derive from that not just here, but you see in the example of Nan Nami, this is a Tractate Kritut, page 11b. Ed echad omer achalta chelev, v'hu omer lo achalti. So here you see a situation that one witness said to someone, you are forbidden to eat, you ate a forbidden fat. As you know, the Torah prohibited us to eat the animal's fat, and the accused said, I did not eat it. So, patu, so the accused is exempt from bringing an offering. So we infer from that, Tama, the amar lo achalti. The reason for that he exempt, because that in the I did not eat, which indicate that he had been agreed, but he said ha'ishtik, but if he display equanimity, if he kept silent and failed to deny the accusation, me'eiman, the lone witness is deemed credible. Alma, what we bring this example is what? Apparently, ed echad me'eman, which means one witness is deemed credible by Torah law with regard to certain issues. Not only that, because the Gemara in Tractate Kiddushin, page 57, said that you cannot slaughter animal of unconsecrated animal in the temple courtyard. So here you see that one witness, it's credible, and we accepted that. So the Gemara said, mideoraita menalan. So mideoraita menalan. So this is credible by Torah law. So menalan, how, from where we derive this? That one witness is enough. Detanya, the Torah said in Leviticus chapter 4 verse 23, O hoda elav chatato. The Torah said, or if his sin be known to him. So this indicates that he himself must be aware of his sin. Velo sheyodi'u acharim, and is not if it was made known to him by others. In other words, one is not obligated to bring an offering due to the testimony of others, even if they testified that he had transgressed. Yachol af al pi she'eno makchisho yeheh patur. So even one witness come and said something, and the one who did it is not sure if he did it or not. Talmud lomar o hoda elav mikol makom. So this is the reason why the verse in the Torah states, if his sin be known to him, which indicate that in any case, however he comes by his knowledge, he is liable. So now the Gemara said, hechedami. What is this? What are the circumstances of this witness? If you tell me that the two witnesses came and said that he is seen, they said that he ate fat and he is not denied. Why need the pasuk? Why need the sentence? Which means only one person came and said it. So the fact that he is not denied, so it means that he is one witness is deemed to be credible. Continue after. So how do you know that this one witness make it credible? Which means, from where do we infer that the reason that due to the fact that one witness is deemed credible, maybe you said because he was quiet, he heard that, and we basically hold that when someone kept silent is considered like he agreed. It's like in a way being acquiesce, or you display equanimity. It's like you agree with what's going on. So Teida, the Ktane Seifa, אמרו שניים אכלת חלב, והוא אומר לו אכלתי. Two people said you ate חלב, by mistake, ate fat. So he said no, patu, he is exempt from sin offering. רבי מחייב, מאיר דינים liable. אומר רבי קל וחומר, אם הביאו שניים לידי מיתה חמורה, לא הביאו לידי הקורבן הקל. So sure, אמרו לו, מה אם ירצה לומר מזיד הייתי? So if he said yes, I did an intentional sinner. So one who was sin intentionally, so he's not liable to bring an offering. So since the accuser in the later clause of the Braita can negate the testimony that will have rendered him liable to bring an offering, he can likewise deny the act itself. So the witness testified that he performed an action that incurred the death penalty, and his denial is no bearing on the case. So they said, the Gemara clarified, and they said, Reisha, at the first clause of the Mishnah 8. What's the reason that the sages hold him? That is obligated. It's because he's trustworthy. And when it's come to Isuim, so one is trustworthy. Even the makrish, including the monetary issues. So kapat rabanan. So they said, so he basically kept quiet, and that's the story. אלא סברה מידי, די מגדה והחתיכה ספק של חלב ספק של שומן. ועד האחד ואמר בריא לי דשומן הוא דמאמן, if one said that it's clear that it's fat, is trustworthy, מי דמי, how do you compare the two? הטעם לא התחזק איסורה. הכה התחזק איסור אשת איש. How do you compare the issue of fat, the issue of married women? Because the married woman, when the husband went far away, and we have here a real predicament, a real quandary, if this prohibition by death of her husband allow her to go ahead and marry, because up to this point she is prohibited because she's a married woman. Now this one witness that come and testify that her husband is passed, that in a way, how do you compare this to the quandary of fat? When it's come to arayot, when it's come to issue of a serious Torah law of abomination in Leviticus 18 that speaks about illicit relations, you have to have two witnesses for this. It's not by all means compared to eating fat. So Gemarrah says, "Alo damya, el chaticha levaday chelev, uvaed v'amar bari li shuman avid lo meiman." So that's one. So because you cannot trust one when it's come to fat. Even the hard witness come and said that it's fat, they're not trustworthy because it's well known that it's fat. If you have two witnesses that say that the husband passed, maybe it will be enough to have one witness that will be trustworthy. So now we go to different direction. So they bring a different source. How? They said, Mide de have a tevel. So maybe we go by comparison to what? To untied produce from which neither truma nor tithe has been separated. Hekdesh, that's like consecrated property. Vekonamot, it's konamot, it's a vow creating prohibition. So such vows are called by the generic term konamot. So the Gemara said, "Hi tevel echadami." What do you mean by an untied produce? If it's him, you should be abdol takno, so he can fix it. El de'acher, which means that someone else have Tramod Maasrot. So he said, "My kasava." What's the question? That he take the truma in order to fix the tevel. He doesn't need the agreement, the agreement of the owner, because if you compare this, it's so different than the Mishnah, because in the Mishnah we said Mishum devi adol takno, you can repair that issue of untied tevel. If you tell me that you need to have the owner's knowledge, and he said, I know with regard to this that it is prepared, he go from an alan, it itself, which is very halacha from where we do derive it. So why in the case of untied produce, like the tevel, more obvious than the testimony with regard to missing husband? So they said hekdesh nami, ikdusha damim. If you have the sanctification of the money, because he can redeem it. He can ask Chacham and ask to abrogate this kedusha. Someone else, not the witness, he sanctified that part. He gufa menalan. Same apply to konamot. Compared to konamot, it's also incorrect to compare it. So the reason that this ed is trustworthy is נאמן משום בידו לפדותו, he can redeem it. סבר את מילה בקונמות, if you tell me that the idea of mistrust is not applied to קונמות, ויסו בעל מאוד דרכי בלי הקודפי, it's only by the way, because the Torah said לא יחל דברו, it's applied here, ידידי משום דבידו, דייצ'ו לעלי. If it's because it's within his power to request the sage to vow be dissolved. אלא דאחר, and you have to say that is another. So if that's the case, ואמר עדיין לא נשיל מרי עלי. And I know that we got to this, that is the owner requested from the sage that the vow be dissolved. He gufa menalan. So itself, the witness deemed credible in this case from where we derive it. So consequently, after the Gemarrah has refuted this attempt to explain why the witness should be deemed credible, the question remains, why is the testimony of a single witness accepted in a case of missing husband? Rab Zera said, you put all these fine. If you look at the list of the 16, so many fines within that list, you allow her at the very beginning to marry someone else. You're lenient at the beginning by accepting the testimony of a single witness to enable the woman to marry. So the Gemara asked, so how about if we not be stringent at the end and not be lenient at the beginning? So they said again, that's the story. That's what we said at the very beginning, the whole story. It's like from the book of Fruit, the first parak, verse 13, they said she's like in jail, aguna. So due to the case that she's deserted wife, the sages were lenient to her. Because think about it, to find two witnesses, it's hard. Because these two witnesses need to go before the court and attest that the husband is dead. So the sages realized that the testimony of one witness were not accepted, the woman will be likely to remain deserted wife, unable to remarry. So to prevent this leniency from causing mistake and an illicit relation, they were very stringent with her in the care where the testimony is found to be erroneous, to ensure that she is very careful not to accept untrustworthy accounts. So on one hand, we want to be careful, but on the other hand, if it's someone that is reliable, you take it. So for sure there is here a discussion of Ritva and Tosfot and many more. We don't have time, but it's much more to discuss on this maybe another time. Now the Mishnah said she married by the witness of one person and then the husband came. She needs to be released from both. Wait a second, he said. The whole story I said is if she got married by one witness, but if there are two, then it's a different story. So she is fine. So now Machacholem Maraba, when here in Eretz Israel is the west of Babylon, they laugh. Ata Gavre Vekai, Vata Marlo Tetze. The husband came back, and you said that she's not released from the second husband. How come she's married to the second one while she's married to the first one? So the Gemara said, here, no, it's necessary in a situation where we do not know the man who comes before us claiming to be the first husband. So the Gemara said, if that's the case, לא צריכה דעתו ביתרי ואמרי אנא נבינן בעדי מכינפי כבדשתא. So there are two witnesses that said we were with him from the where he left until now, and it is you ואתון הוא דלא ידיתו לדכתיב ואיך יוסף דך והם לא יכירו, that we recognize him like they said in last week parasha. Yosef recognized his brothers but they did not recognize him. Yosef left without beard, came with a beard, so it's hard to recognize him. So it shows that one appearance can change so much over time that even his own family members are unable to identify him. There's Gemarrah in Bava Lamentet 39. They say that it's a big issue if really nobody recognizes him or not. Anyway, sof trei utrei ninu. And ultimately there are 2 against 2. Initially 2 witnesses testify that the man is dead, and another pair arrives saying that he's alive. So why should this testimony of the witnesses who said he's dead accepted, allowing her to remain in the second husband, while the other witnesses claim that he's still alive? 88b, if someone unwittingly have relation with her, so he needs to bring and the offering korban hasham, that uncertain guilt offering. So they said, you know what's happened? She married to one of her witnesses who testified that her husband had died. So here's this, it's not so simple, right? Because since the witness himself has no doubt as to the truth, he's not liable to bring an uncertain guilt offering. So it's a rushing to Bot 22 that it's not so simple, because in general term, the moment you witness, you're an outsider. Now you witness and then you go and marry her, right? So they said, Higu from Be'asham Talui Kaima. So the Gemara said, the question is, she herself is stand obligated to bring uncertain guilt offering. So they said, Be'omeret Barili. She said clear that this is not my husband. Yachei, Mailem Emra, Afilu Rab Nachman bar Rabbi Yossi. לא כאמר לה שבאו עדים ואחר כך נישאת, אבל נישאת ואחר כך באו עדים, לא אמר דתניא. 2 אומרים מת, 2 אומרים לא מת. 2 witnesses said he is dead, 2 said not. 2 אומרים נתגרשה ו2 לא נתגרשה. 2 said that she divorced, 2 said not. She's still married. הרי לא תינשא, she cannot marry someone else. ואם נישאת, if she violated the law and married to one of those witnesses that said that she is allowed to marry someone else, לא תצא. She is still married to a second husband. Rabbi Nachman Rabbi Yossi amar teitze. She have to be out of that marriage. אמר רבי נחמן ברבי יוסי, מה אני אומר שתצא? בזמן שבאו עדים ואחר כך נישאת. First the witness and then she married. אבל נישאת ואחר כך באו עדים, הרי זה לא תצא. But if she's married, then the witness came, then not out. So why Rab need to repeat this rule? כי כמה רב נמי, בזמן שבאו עדים ואחר כך נישאת, להפוקים ברבי מנחם ברבי יוסי. That's one way. Another way, ואיכא דאמר, תמא דנישאת ואחר כך באו עדים. אבל באו עדים ואחר כך נישאת, תצא, כמעט מקדעת, כמנחם ברבי יוסי. מטיב רבא. So Rava raised an objection from the Braita. They said in Leviticus 21 that the Kohanim cannot contaminate to the dead body and they cannot marry women that prohibited to them. מנהל שאם לא רצה דפנו. How do you know that if the Kohen does not want to observe this trick against disqualified woman, that the court forces him? By that time they give a malkot, flogging him, and to sanctify him to despite his wishes. Talmud lomar v'kidashto be'al kocho. The Torah said you sanctified him, it's against his will. So Rabbi elaborated that. He said, give me an example. He said, if you tell me that she's not married to one of the witnesses, ולא כאמרי לברילי, צריכה למרד לדפנו, so why need to say it? אליו דניסד לאחד מידע. וכאמרה ברילי, וכתה לדפנו. So he said, alma mapkina laminej, we derive from that if it's an issue of Eshet Ish that's married, so release not the way that Rav said. So the Gemara said, Isu kehuna shani. When it's come to the issue of kehuna, it's different. Said, Vibai tema, dapno, my dapno be'edim. So another one, it's what does that mean that you forcing? It's when you have edim, meaning before he married, to avoid him from married by the witness of the first 2 edim. והיא באה איתה עימה, כשבאו עדים ואחר כך נישאת, ורבי נחמן ברו יוסי, so he allowed them to be together, only if they married before the second group came. So רב אשי אומר, מה לא תצא לכמה רב? לא תצא מהיתר הראשון. So she, it means that she need not to leave her state of being permitted to her first husband. Since she married according to halacha on the basis of witness testimony, she's considered to have acted under the duress, like any other woman not married to a Kohen who was unfaithful against her will. She may return to her first husband upon his return. So the Gemara said, question, Amar Rav Chada Zimna, Rav said once, because we learned in the Mishnah, Letnan, Niset Shlo Bershut, Muter Lachzor Lo. Amar Rav Huda, Amar Rav, Hachi Ilcheta. So he said in page 91, that that's the halacha, that if she got married without the consent of the Beit Din, only by the witness of 2 witnesses, and then the husband returned, she can go back to her husband, original. So Rav Huna said that that's the halacha, so I need to repeat. So it's Hada Michlala de Chaverta Ka'amar. One ruling was stated by inference from the other. In other words, Rav did not state both halacha explicitly, but only one of them, from which his other statement was inferred. Omar Shmuel. Now, the Mishnah said that she can marry by 1 witness. And then the husband returned, she needs to be released from both husbands. So the Gemara put some boundaries against that. Amar Shmuel said, Lo shanu ela shelo mekachashto. The only idea is if she does not contradict the witness who claim her first husband is alive. Haval mekachashto lo tetze. However, if she contradicts him, she need not to leave her second husband. So the Gemara said, "B'mayaskinan, what are you talking about? Ilam beitrei. If you tell me that there are 2 witnesses that come and said it, ki makhashta alei my have. What's the idea if she denied it? She contradicted. Ela bechad, he said it's only 1 witness. Tama lemekachashto hashadka. Let's say if she quiet, so she needs to release from the second husband. V'amaru la kol makom she'im Torah echad, harei kan shnayim. Any place that the Torah allowed 1 witness, it's considered as 2. So it means if 1 witness said that the husband is dead, so it's the same as the 2. So ve'en dvarav shel echad bimkom shnayim. You can't say that 1 witness applies to 2. So how come we accepted that, testified when the one testified that the husband is dead? The Rabbi Nechemia talk about those witnesses that not valid. The Tanya Rabbi Nechemia Omer, כל מקום שמן התורה עד אחד, עליך אחריו רוב דעות. If the Torah allows one witness, so relies 1 witness, this is a full testimony equal to that of 2 witnesses. הרי כאן 2, בין דבריו של אחד במקום 2. So this is a full testimony equal to 2 witnesses, and the statement of 1 witness has no bearing in a place where is they contradicted by 2 witnesses. So if so, there is no difference between 1 witness and 2 witnesses in this case. So the Gemara asks, Hacha b'ma yaskinan b'psulei edut Rabbi Nechemia. So we talk about psulei edut, disqualified giving testimony, the follow Rabbi Nechemia. Tanya Rabbi Nechemia Omer, כל מקום שמן התורה עד אחד, עליך אחר רוב דעות. When you go follow 1 witness, you follow by the majority of opinion. ועשו 2 נשים באיש אחד, כי 2 אנשים באיש אחד. So in these cases, they establish the testimony of 2 women against 1 man, like the testimony of 2 men against 1 man, whose claim is not considered equivalent to 2. So in this case, if the wife also contradicts their account, she joins the single witness, and therefore the testimony of disqualified witness is not accepted. Vi ba'it eima is another option to understand this. כל אחד היה תעד אחד כאשר מעיקרא, אפילו מהנשים כאל אחד דמיין. אך המעסקן גודל האישה מעיקרא. So women come. So they said, ותרצה לרב נחמיה האחי, ונחמיה אמר כל מקום שמן תורה עד אחד עליך רוב דעות. ועשו 2 נשים באישה אחת, כי 2 אנשים באיש אחד. אבל 2 נשים באיש אחד כפלגה ופלגה דמי. But when you have a case involving two men against one man, who is a valid witness, this is like a half against half, which means they are equal. With regard to Shmuel's statement, if the wife herself remains silent, the testimony of the first woman that the husband is dead has been negated, as the account was contradicted by two women. But if the claim of the wife is joined to that of the first woman, she needs not to leave her second husband, and that's the big chidush here. And for sure there are many practical halachot involved with this. Shulchan Aruch Even HaEzer 17. If a woman's husband left for overseas and she was informed that he was dead and she married another man, after which her husband returned, she must leave both of them. She requires as a bill of divorce a get from both of them, and she does not receive from either of them any payment for her marriage contract, the proofing for property, or left or worn out clothes she bought in marriage. If the Kohen, so it cannot contaminate to that, and furthermore they are not entitled to her earning of lost article she find. So it means that it goes in both ways, and if it's a Levi rights, they need וחליצה, not ייבום. Another interesting halacha is Rambam in Chod Gerushin chapter 12, and also Shulchan Aruch Even HaEzer 17. If a woman's husband went overseas and she received testimony that he died, even if he was only one witness, or even the witness was a woman, a relative, a slave, or a maidservant, or even it was a hearsay evidence from a string of invalid witness, the witness is deemed credible, which is very rare. It's extreme kula here. Another point is the idea of displaying equanimity, being silent, being akuyas. This is the Rambam in Chod Gagot chapter 3. If testimony was received that someone had performed a transgression for which he is liable to bring a sin offering, and the accuser remained silent and did not contradict the claim, he is obligated to bring an offering even if the testimony was delivered by a single witness, or in a sense, single woman is the same way they treated her. אין דבר שבערבה פחות משניים. That's important. הלכה in Shulchan Aruch Even HaEzer chapter 11. The rabbinic court will compel a man to divorce his wife only if two witnesses testified that she committed adultery willingly. But again, but this matter, you need to have two. You cannot go by one. Mishum iguna akilu rabanan. That's the Rambam in Chod Gerushin chapter 13. The sages are lenient with regard to testimony that a woman's husband has died. Hearsay testimony, which usually is not accepted, here it is accepted, as well as testimony of disqualified witnesses, and even the incidental, unconsidered remark of a idolater. The reason is that there is no concern that they might be lying in a case of this kind, and the sages did everything within the power to prevent occurrences of deserted wife being unable to remarry. If in the case that sheniset le'echad me'edea, that's again Even HaEzer 17, if the two witnesses said that the woman's husband is dead and two others testify that he's not dead, she may not remarry. If she married one of the witnesses who claim her husband is dead, and she herself says that she is sure that he is dead, she need not leave her second husband, but basically the statement of Rav Sheshet. So we said in that Even HaEzer, if a lone witness came and informed a woman that the husband died, and she married on the basis of his testimony, and afterward another witness arrived and testified that he is not dead, the woman does not lose her status of being permitted to her second husband. The reason is that with regard to testimony about missing husband, the witnesses who renders her permitted is considered like two witnesses in regular cases as stated by Ula. And I want to repeat my disclaimer, which I said at the very beginning of this session, that any practical halachot, we need to ask a permanent posek before ruling, and that's just להגדיל תורה לאדירה.
לשולוים מלאכי השולוים מלאכי